I'll wait on there. That's where it's going. Both have to be muted. Lower right hand icon, speaker has to be turned off on the computer and mute on Zoom. Test. Test. Other one has next to test TV. All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call the docket. That's still not good. When I call your name, please say present or here. Raise your hand. Jason Barnes. Randy Dobbins. Randy Lee Dobbins. Aaron Ham. Martese Heath. Martese Khalil Heath. Neil Jones. Neil Justin Jones. Jennifer Rollins. Jennifer Danielle Rollins. Today is Thursday, right? Make sure it's the wrong day. Michelle Blaylock. Waiver of arraignment filed, approved, pretrial set, September 22nd. Carlos Gatlin. Court has received information that Mr. Gatlin was in the emergency room this morning. A court coordinator spoke with the ER physician. The court's going to have his name called. If he does not appear, the court will issue a judgment nisi, but take it under advisement until we get more documentation from the ER.
Very much close. For any motion.
Kenneth Nash. Kimberly Cohn.
Here.
John Piercefield. Carlos Padron. Anthony Brown. Waiver of arraignment filed, approved, pretrial set, September 22nd. Zachary Elliott. James Rife. Royce White. Royce Latate White. Bobby Brand.
Judge, Mr. Brand is currently in the Millwood Hospital in Arlington. I believe that his father was providing documentation to Ms. Abraham as to his status.
All right, court will call his name and take an eyesight under advisement. We'll do that at a later time. Glenn Christopher. Glenn Coleman Christopher.
Judge, Mr. Christopher is currently being housed in the Coffin County Jail.
On different charges.
Yes, Judge.
Jennifer Gonzalez. Jennifer Lynn Gonzalez. Michael Lobb. Lanaria Miles. Kaylee Pettis.
Judge, Ms. Pettis contacted me this morning. Her ride fell through. She is seeking to get another ride. She may be a little bit late this morning.
Thank you, Mr. Manning. Ronald Polly. Mr. Polly, I want you to come on forward and meet with the pretrial release officers, and I'm going to drug test you this morning. Cameron Roberts. Here. Brittany Turner. Brittany Deshaya Turner. Thomas Meek. A note that he was verified in the Seymour unit with a projected release date of February 15th of 23. State have any announcement on Mr. Meek, if there's intentions to bench warrant him back before that time or just leave a hold? I'll come back to that one just real quick. Dwegan Toms. Dugan Toms. Andrea Young. Lana Calder. Alfonso Medina. Carmelita Chitty. Jamie Hedden. Your Honor, that's going to be resolved today. Thank you, Swain. Shane Baronet. And then we'll call Megan Tyler at 11:15. All right, counsel, do we have anyone that's ready? Anyone? Anyone? Bueller?
Judge, I'll go ahead and have some resets.
Who'd you like to call first, Mr. Manning?
Mr. Michael Lobb.
Mr. Lobb, if you'll come forward, sir. This is CR 2269 docket call.
That's correct, Judge. We're announced ready. As we said, the jury selection docket.
All right, and can you tell me what, if any, the offer was from the state that's been rejected by the defendant?
I believe the final offer was 15 years TDC.
All right, court will find that Mr. Lobb has rejected the state's offer. Court will set Mr. Lobb for jury selection. We'll begin that on October 3rd at 8:30. Mr. Lobb, you will report to the courthouse downstairs. A jury will be in panel that day. Your case will not go to trial. That will be your first setting. You'll be put on the list of trials. And once your case reaches the top of the list, then you'll be tried. Okay. Mr. Manning's not going to be required to be here. So you'll simply check in. You'll meet with your pretrial release officer if he's here. Make sure that, you know, you're taking care of all of those requirements. If that's taken care of, then you'll meet my staff. They'll give you a reset date and you'll leave, and you'll continue to do that month to month until your case is reached a trial. Okay. Yes, sir. All right, Mr. Lobb, once you sign and get the yellow copy, you're free to go.
Mr. Cameron Roberts.
Mr. Roberts. CR 19290, motion to adjudicate.
Yes, Judge. I was just pointing on Mr. Roberts' case recently. I have not had an opportunity to go over the motion to revoke with him. However, I spoke to him and spoke to probation, and we'll be speaking to the state to see how they want to resolve this case. We request to be reset for the contested motion to revoke docket for next month.
Any objection to the state? No. All right, court will set Mr. Roberts for contested hearing on September 29th. That'll be at 9 a.m. Ticket, please. All right, Mr. Meany, I believe that there's a question on whether or not Mr. Roberts has an outstanding warrant. So what I'm going to do at this time, I'm going to detain him in the jury box here to allow the deputies to confirm whether that's live or not. Okay, so Mr. Roberts, you're going to come over here and have a seat, and then the deputies will direct you further.
Court's information, we will not be proceeding against this being posted in the motion for discussion. Mr. Sanders needs.
Mr. Manning, any other clients that are you ready on?
The state and I have reached a disposition on that. We're going to,
I think he's given a your analysis.
Okay.
Showed that he failed to report on pretrial release for 2 months in a row
okay,
for June and July. So I'm just having him UA. We'll call him back here in just a second.
excellent.
Anyone else? Have any other counsel that's ready? Mr. Jeff White, are you waiting on paperwork? Do you need time?
Waiting on
Paperwork. And you just have Ms. Chitty today, so that'll be a plea. Okay. All right. Mr. Nolan Watts waiting on paperwork. Mr. Stevens is waiting on paperwork.
How's that for efficiency?
Jeff Sanders, Jeff Sanders, please. Jason Barnes, come on up, sir. Come on around this way, up to these podiums. There you go. Right there, out of that podium. There you go, sir. All right, this is cause number CR 22201. State versus Jason Lee Barnes. Mr. Barnes, you have been indicted with a first-degree felony offense of aggravated robbery. If convicted and sentenced for that type of crime, that level, you would be facing potential incarceration in the Texas Department of Criminal Justice for not less than 5 years, up to a maximum of 99 years or life, an optional fine not to exceed $10,000. Today, we're set for arraignment. Do you have an attorney that represents you?
The moment.
Do you intend to hire an attorney?
I need one appointed or something. I don't have the money for it.
Have you already requested a court appointed attorney?
Yes, sir.
You did request a court appointed attorney. When did you do that?
Today.
Today you did? Okay, just filled it out? Okay, I'm sorry. I didn't have that notated on my docket. So just go ahead and have a seat and I'll call you back up in a few minutes.
All right.
Aaron Ham. All right, this is the state versus Aaron Jason Ham, CR 22216. Mr. Ham, you've been indicted on the charge of assault of a family or household member by impeding breath or circulation. Third-degree felony carries potential punishment range not less than 2 years, up to 10 years in prison, and a fine not to exceed $10,000. Do you have an attorney that represents you?
Oh, yes, sir. I just got one yesterday. Ashmore.
Okay, did you hire Mr. Ashmore?
They're doing all the paperwork, so he is on leave right now and he's coming back this end of the week. So.
Okay, so it is your intention to have you paid the office? Have you retained Mr. Ashmore? Have you given him
No,
money?
sir. They were the Rockwell office was getting all that collected today for me to do.
Okay, so if I reset the case, that will give you time to complete that retention?
Yes, sir.
Okay. All right, what I'll do, Mr. Ham, is I will reset you until September 22nd. for arraignment and to hire Mr. Ashmore. And so what I'm gonna ask that you do, Mr. Cam, also, is I'm gonna have you sign this notice of setting. And then I want you to report to your pretrial release officers. Are you aware that you're on conditions of pretrial release?
Yes, sir, I am.
Okay, I show that that you failed to report and that you're delinquent on your monies. So I'm gonna need you to report to probation to or pretrial release to take care of that.
Yes.
All right, Mr. Ham, Deputy Everett's gonna bring this form to you. It's just a reset form, has the date for your reset. We're gonna give you a copy of that if you'll sign that form.
So,
All right, you can come on around here in the front and meet with pretrial release office. And then we'll see you back on September 22nd. Is Randy Dobbins here? Martese Heath or Martese Heath? Neil Jones? Jennifer Rollins? Kimberly Cohn? Ms. Cohn, I want you to come up here in front of me, okay?
pass slip.
All right, in cause number CR 2275, State versus John Daniel Piercefield, the court acknowledges that Ms. Casey Chester is on maternity leave, and the court is going to reset today's docket call till September 27th. Court has given Mr. Piercefield a copy of that notice and has ordered him to report to pretrial services. Carlos Padron, CR 21336.
Thank you, Your Honor. Was up front or here?
Right there. All right, I show that we were set for plea today.
Yes, if we could just have one more setting, our actual prosecutor's out. The offer's 4 years deferred with a $2,000 fine. I'd kind of like to get that down. We could just reset it so I could talk to the prosecutor. Tim is nice enough to agree to pass the case, but he doesn't want to step under the prosecutor's feet to, work a new deal. So.
Judge, that plea offer was made many months ago in the same system that all our plea offers are made. Mr. Crane signed up for Discovery Portal yesterday finally, after several months of representing Mr. Padron after waiving jury trial, and finally signed up and got Discovery yesterday, picked it up from the office. Why he's waited this long to talk to Ms. Heisel about it, I don't know, Judge, but that is our plea offer. I doubt that it changes, but that's fine.
State's not opposed to the request for an additional docket call.
No, you're.
Okay. All right, court will reset Mr. Padron to enter his plea before the court, and we'll do so. Are you available on September 22nd or 27th?
Tuesday to a Thursday, which one we got there?
20, we could do the 20th, the 22nd, or the 27th.
How about the
20th, the 20th and the 27th are both Tuesdays. 22nd?
Yes, sir.
That'd be a Thursday.
That'd be fine. Okay, thank you.
All right, court recess Mr. Padron for plea on September 22nd. That'll be at 9 a.m.
Sure. Thank you, sir.
And Mr. Padron, once you sign and get the yellow copy, you're free to go.
Very good. And just to let you know, signing up for Discovery in this county is not that easy. I started working on this about a month ago. I know that was a little bit late. I have a very busy schedule, and I'm sorry.
Okay,
Thank you,
appreciate
sir.
that.
And Judge, it is not difficult. He has to fill out his name, his address, and check Van Zandt County. That's all he has to do, but he does have to do it. He had made no inquiry about how to do it, and one of my legal assistants saw on the docket, and she reached out to him to tell him how to do it. That was in April. He responded on July 5th, and finally yesterday, he filled out his name, address, and checked Van Zandt County. It's not difficult. The court can ask any other defense lawyer.
Thank you. You're welcome. Mr. Roberts, you're free to go. Thank you, Ms. Mann. Mr. Hawkins, are you ready? Mr. Wright, you'll come forward, sir. CR 21307-308. Set or docket call today.
Yes, Your Honor. Your Honor, we reached an agreement for an actual plea on this case. We'd asked the court for a plea date sometime in October. I know that's more than 30, 45 days out, but Mr. Ripe has some real estate property that he's got to find someone to manage in the meantime to be able to take care of that so he can take care of his obligation here.
Any opposition from the state? Will the plea be for time or probation?
It's a TDC.
TDC?
Yes, sir.
Okay, so we'll need to set it in the afternoon.
Yes, Your Honor.
Okay. All right, court, what about the latest I got in October is October 25th. I have others available, but that's the latest in October.
I'm all right if you go longer.
October 25th is fine, Judge.
Okay. All right, court sets Mr. Wright enters plea October 25th. That will be at 1:30. And Mr. Ripe, I want you to appear at the Banzai County Justice Center at 1:30. They'll let you in and we'll do the plea out there. You'll be taken into custody that day, okay?
Thank you, Your Honor.
You're welcome.
The next one is Royce White.
Did he show up?
He's here, Your
Oh,
Honor.
he is. Royce White, CR 21-398, CR 22-51. All right, go ahead, Mr. Hawkins. Separate docket call, I believe, each case.
It is, Your Honor. The state has made an offer. At this time, my client has rejected the offer, and so we need a jury trial setting.
All right, what's the offer that has been extended and rejected?
Judge, it was a 15 TDC on the theft case, and it was a 1245 on the assault case, the domestic assault case. I believe it's.
All right, court will note for the record that Mr. White has rejected the state's offer. Court will not allow Mr. White to enter into a plea agreement after today's date. Court will set Mr. White for jury selection beginning October 3rd. That will be at 8:30. So Mr. White, you'll appear downstairs. You'll check in with the court staff. They'll give you your next setting. And you will continue to do that until your case is called for trial. You won't go to trial on October 3rd. That'll be your first setting. You'll receive a new day. Or we'll have, court staff will have you fill out that paperwork. Mr. Hawkins is not going to be required to be here, so I don't expect him to be here. You stay in contact with him, and you need to stay in contact with the pretrial release officer.
Yes, sir.
Okay.
Sir.
All right, once you sign, you get the yellow copy, free to go. Yes. All right. Ms. Calder, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. Make sure you speak up loudly and clearly for me so I can hear you, okay? Your name is Lana Michelle Calder, is that right?
Yes, sir.
And Ms. Calder, did you sign two documents with your attorney called Waiver of Jury Trial?
Yes, sir, I did.
And did you read that document?
Yes, sir, I
Did
did.
you discuss that with Mr. Stevens, your attorney?
Yes, sir.
You're telling the court that you wish to waive your right to a jury trial in this case and to resolve your case by plea agreement. Is that right?
Yes, sir.
Ms. Calder, do you understand that you have the absolute right to a jury trial?
Yes, sir, I do.
That right can't be taken away from you. That means you have the right to make the state prove their case beyond a reasonable doubt in front of a jury. And for that jury to decide whether you are guilty or not guilty. You understand that?
Yes, sir, I do.
And it's before that jury that you would have the right to cross-examine the state's witnesses, confront their evidence. You understand that?
Yes, sir, I do.
While that right cannot be taken away from you, you can waive that right, so long as your waiver is intelligent, knowing, and voluntary. You understand that? That means that the decision that you've made is your decision. And is that your decision in this case, is to waive your right to a jury trial?
Yes, sir.
And you understand that if the court approves this waiver, that right may not be restored to you.
Yes, sir, I do.
Means if you change your mind later between now and the plea agreement and you decide you want a trial, you would still have a trial, but it would not be in front of a jury. It'd be in front of a judge like me. You understand?
Yes, sir, I do understand.
Okay. All right. And Mr. Stevens, do you join with Ms. Calder on her request for the court to approve her waiver of jury trial? Yes, I do, Your Honor. Court will also take judicial notice that the attorney for the state has waived the state's right to a jury trial in this case and has joined Ms. Calder in her request. Court will find that Ms. Calder's waiver of jury trial after admonishments is intentional, knowing, and voluntary. All right, court will enter that into the record, and court sets Ms. Calder for docket call. Are you available? I'm sorry, we'll set for plea. Are you available on September 20th or 22nd?
Judge, I'm on vacation the 20th of September. I actually come back on the 21st.
What about the 27th?
That would be good, Judge. I'm in your court anyway, that afternoon.
That afternoon?
Yes, sir. The
And
27th.
is Ms. Calder's plea for time or?
It will be for time. Yes, Your Honor.
Time. Okay, so you're fine with the 27th?
Yes, sir.
Okay, all right, court sets Ms. Calder then for September 27th. That will be at 1:30. And Ms. Calder, you will appear out at the Van Zandt County Justice Center. All right,
Yes, sir.
all right, once you sign and get the yellow copy, you're free to go. Alfonso Medina, CR 22-112. All right, Mr. Medina, if you'll raise your right hand, I'm gonna place you under oath. Sir, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, lower your hand. All right, it appears that Mr. Medina wants to enter a plea, an open plea to the court today to the second-degree felony offensive manslaughter. Is that correct, Ms. Curry?
Yes, Your Honor.
And there's no plea agreement in this case. Is that correct?
That's correct.
And so it's Mr. Medina's intention to plead open to the court.
I believe so, Judge.
Is there any request by the defense with regards to this open plea?
That is correct, Your Honor. We are going open straight to the court.
Is Mr. Medina asking the court to accept the plea today and defer any finding of guilt until time of sentencing?
Yes, that is correct, Your Honor.
All right, Mr. Medina, your name is Alfonso Jeffrey Medina. Is that correct?
Yes, sir.
All right, Mr. Medina, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you have been represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Sir.
You feel like you've had enough time to discuss your case with him, and have all of your legal questions answered?
Sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
I don't understand a lot of this, honestly, but I'm gonna take responsibility for my actions.
Okay, and can you tell me some things that you don't understand so the court can make sure that you understand before we go forward?
I lost focus. Could you repeat yourself, sir?
Yeah, I want you to tell me exactly what you have questions about so that the court can address it to make sure that you understand what you're doing in court today, the legal implications, ramifications of that, so that you can make a decision that's intelligent, knowing, and voluntary.
Thanks. Really want to go and ask about how papers you signed. If you had any questions or anything, you said you had a lot of concerns or questions. That's what he's trying to find out. If you got any specific questions pertaining to the paper.
Sorry, my head and I can't understand anything. Just taking responsibility, because this is my fault.
Do you understand the papers that you signed? Okay, we went over them, correct? And you do understand by doing this, you're giving up your right for trial.
I understand.
You're giving up your right to bring witnesses to present on your behalf. You're giving up your right to cross-examine the state witness. You realize that, correct? Okay, and by doing so, you realize also that when we do the sentencing, the judge has a full range available to you for punishment. In other words, he could sentence you anywhere from 10 to 20 years in prison. You understand that?
Yes, sir.
Or he could put you on probation between 2 to 10 years. You also understand that? Okay, so you waived your right to a jury trial. Is it your intention to voluntarily and knowingly and intelligently waive your right to a jury trial and ask the judge to reset the case for sentencing? Is this? Yeah, what we talked about, there'll be a pre-sentence investigation report done. We'll get a copy of that. Sometime thereafter, we'll come back to court for sentencing. Do you understand the procedure? Is that what you want to do?
Yes.
Are you making this decision freely and voluntarily?
Out of pure honesty, I'm doing it because David was a really good friend of mine. And I'm
Is it-
taking full responsibility because this is my fault.
Is anyone forcing you to do this?
Absolutely not.
You're doing this on your own volition. Pass the witness.
Mr. Stevens, do you believe Mr. Medina to be competent today?
Yes, sir.
And you've explained to him his legal rights as they pertain to this case.
Yes, sir.
Do you believe that he understands what his legal rights are?
Yes, sir, he does.
And do you believe that he understands the consequences of his plea today?
Yes, sir, he does.
All right, Mr. Medina, the charge of manslaughter is a second-degree felony, and it does carry a potential range of punishment of not less than 2 years up to a maximum 20 years in prison and a fine not to exceed $10,000. Do you understand that full range of punishment? Understanding what the full range of punishment is, understanding that if you enter a plea of guilty to this case, then the court could impose a sentence anywhere within that range. Do you understand that?
Yes, sir, I understand.
Understanding that range of punishment, understanding what your plea is today, and that I want to ask you in just a moment how you plead. If you plead guilty, you understand the legal effects of that plea. Is that correct? You have to say out loud.
Yes.
All right, so Mr. Medina, understanding all of that, you still wish to go forward?
Yes, sir, I do.
All right, Mr. Medina, to the charge of manslaughter, how do you plead? Are you pleading guilty because you are guilty of committing that crime and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty to this crime? No, sir. Court will accept the defendant's plea of guilt. Mr. Stevens, any objection to the state's evidence and the stipulation of evidence?
No objection, Your Honor.
Stipulation of evidence is admitted as State's Exhibit 1, and the court does take judicial notice of the defendant's judicial confession in this case. Anything further from the state on the issue of guilt?
No, Your Honor.
Anything further from the defense on the issue of guilt?
No, Your Honor.
All right, the court has accepted Mr. Medina's plea of guilt. Court will defer a finding of guilt at this time until a pre-sentence investigation can be conducted regarding this case. The court will set this matter for sentencing. Is there a specific time request from either the state or the defense to accomplish the PSI?
No, Your Honor.
I'd like to give the Community Supervision Corrections Department at least 30 days. So what we're going to do is we're going to set it for September 29th on the contested docket. That will be at 9 a.m. For the record, the court has received the victim impact statement as provided by the district attorney's office. The court has reviewed that, has signed the statutory acknowledgement, and returned that to the DA's office.
Thank you, Judge.
May he be excused, Your Honor?
Yes, and so Mr. Medina, the Community Supervision and Corrections Department will be in contact with you to set up a time and date to interview you and conduct the pre-sentence investigation. So to be mindful of receiving calls and making sure you're checking your messages and get that appointment set with them. They'll reach out to you, okay? And then we'll see you back on September 29th at 9 a.m.
Between what times do you think they would call me?
I'm not sure. I'm not sure. Just if
He's asking Judge because he works all night long. He gets off like at 5 or 6 in the morning.
I get off around between 8 and 9.
they'll leave a voicemail if you have a voicemail set up. If you don't have a voicemail set up, you get one set up. They'll leave a voicemail and you can return their call. Okay. All right, and Mr. Medina, if you want to, you can come back and meet with the community supervision officers now and try to set that up. Is Glenn Coleman Christopher here? Neil Jones, CR 22-219. Come on up, Mr. Jones, to these podiums right up here, sir. All right, CR 22-219. Mr. Jones, you are set for arraignment today on the state jail felony charge of possession of marijuana greater than 4 ounces, less than 5 pounds. A state jail felony in Texas has a range of punishment of not less than 6 months in prison, up to a maximum 2 years in prison, and you could also receive a fine up to $10,000. Do you intend to hire an attorney to represent you in this matter? Yes. All right, and who do you intend to hire? Evelyn White. Okay, if I reset your case, Mr. Jones, will that give you time to retain Mr. White and have him here with you in court? Definitely, Your Honor. All right, today is the 11th. I'm going to reset you. Is Mr. White still here?
Just a chance. I don't know if they're where he's been. He's here somewhere.
Would you ask Mr. White to come in? I just want to check with him on calendaring. When do you plan to hire Mr. White, Mr. Jones? This week. This week. Okay. Sure. Mr. White, I'm sorry to bother you. Mr. Jones has indicated that he intends to hire you in this case. And so what I'm going to do is I'm just going to reset this so that he can do that if that's what he's going to do. But I wanted to set it if you do get retained on the day that you would be here. So
Yes, sir.
I was just going to ask you, do you remember if you were going to be here on September 20th or 22nd?
I'm gonna be here on September
20th? Okay, thank you, sir. That's all. All right, Mr. Jones, court will reset you for arraignment on September 20th and give you time to hire Mr. White or any other licensed Texas attorney. Thank you, Your Honor. You're welcome. After you sign that, Mr. Jones, we're going to give you a copy, and then I want you to come over here and meet with our pretrial release officers, and they have more paperwork for you, okay? Okay. Mr. Schmidt, you ready? Who are you ready on?
I have Dugan Tom, CR 22-158.
He's here now?
He is.
Okay. Dugan Toms, you'll come forward. All right, Mr. Toms is set for pretrial, Mr. Schmidt.
That's correct, Judge. At this time, we don't have any contested pretrial. Has to be set for that September 20th docket call.
All right, court will set Mr. Toms for docket call on September 20th at 9 a.m. Mr. Toms will need to sign his conditions of pretrial release. Mr. Toms, court starts at 9 o'clock. I was here, Mr. Schmidt was here. We were waiting. Where were you at?
My car battery had trouble, so
We need to make sure that you get up early enough to handle those issues so that you can be here on time. Otherwise, court's going to end up issuing a warrant. It's going to be hard for Mr. Schmidt to represent you. He's got to, one, find you, and two, he's got to go sit out in the jail and wait for you to be brought up. You understand? All right, come over here and meet with the pretrial release officers. You're going to sign those conditions of pretrial release. And then also, I need you to go, listen, I need you to go to the end of the hall when you're done with these officers. Go to the end of the hall on the left. You need to meet with Miss LaPrade. I show that you owe over $15,000 on other criminal cases that you never paid on. We've got to get something set up on that. Otherwise, you're going to end up going to jail. $15,000, $100 a day, long time. Okay, all right.
See this happening.
All right, Mr. Adams, you ready? Is this Mr. Nash?
It is, Your Honor.
Kenneth Nash, CR 2271, set for docket call.
Yes, Your Honor. Mitch Adams on behalf of Mr. Nash. He's present. He's present in the courtroom today. We've received a revised plea offer in this case. We received it a couple of weeks ago. There is a lot involved with that new plea offer that I need to discuss with Mr. Nash. I haven't had the opportunity to do that in the past couple of weeks since I received it, and so I would like the court to set us for one more docket call to give us a couple of 4 weeks to be able to have that conversation. When we come back, we'll be able to tell the court whether we're going to resolve this with a plea agreement or if we're going to go to trial.
Any opposition from the state?
No, Your Honor.
Okay. All right, court will extend Mr. Nash's additional docket call. We'll reset this. I have the 20th or 22nd available, Mr. Adams.
22nd.
22nd. All right, court sets Mr. Nash for docket call September 22nd at 9 a.m. Once you sign and get the yellow copy, you're free to go.
Yes, sir. Thank you. I have two other cases this morning, Judge, but I think one of them is Mr. Gatlin, who's not with us.
And then Ms. Blaylock, you had a waiver of arraignment.
Right.
Court approved that, set that on September 22nd also.
Yes, sir. That's all I have for the morning, Your Honor. Maybe excuse till the afternoon.
Well, let's go ahead and call Carlos Gatlin, CR 21288. Court will find that Mr. Gatlin's not present at this time, nor when his name was called at 9 a.m. The court has received and verified information that he was presented himself in the emergency room. Where that was at? Presented himself to some emergency room in which my staff spoke with the ER physician. So what the court will do, we'll have his name called at the end of the docket. If he's not here, the court will consider issuing a judgment nasi alias capias, but I will take that under advisement until the close of business tomorrow, the 12th, and expect that Mr. Gatlin will provide the court with will order him to provide the court with a copy of his documentation as to his ER visit to determine whether or not his absence is legitimate.
Understood. We'll do our best to get a hold of Mr. Gatlin to make that happen. And I would just point out for the record, he's been here consistently for his past court dates. So hopefully we'll get it sorted out for him.
I'll tell you what, let's extend that. We'll extend that through Monday. We'll give him till Monday, close of business. That way if he's admitted or something or has bigger issues, we'll extend that and give him more time till close of business on Monday, August 15th.
Thank you, Your Honor.
You're welcome. All right, Mr. Manning, are you ready? I know that we've appointed Ms. Cohn to you this morning.
Yes, Judge, I'm ready on several.
Okay, all right, let's go with Ms. Cohn, CR 22174. Ms. Cohn is set for arraignment. The court wants to note that Ms. Cohn has been found to be indigent. The court appointed the Honorable Casey Chester to represent Ms. Cohn. Ms. Chester is away on maternity leave with a return date estimated greater than 30 to 45 days. So the court has removed Ms. Chester and appointed the Honorable Jonathan Manning to represent Ms. Cone. And she's set for arraignment on injury to a child, elderly, or disabled individual, third-degree felony. Go ahead, Mr. McCoy.
Yes, Judge. I had an opportunity to speak with Ms. Cone. We discussed the charge against her. Her name is spelled correctly. She understands the charge against her, the range of punishment. And this time request a plea of not guilty and request to be set on the pretrial docket.
All right, court will enter Ms. Cone's plea of not guilty into the record. Court will find that she's waived the formal requirements of arraignment. The court will set her for pretrial on September 22nd, unless there's any issue with that, Mr. Mayor.
Judge, I don't believe so, but give me just one moment to confirm. September 22nd, Judge.
All right, that will be at 9 a.m. And Ms. Cone, once you sign and get the yellow copy, you're free to go.
Judge, I'm also ready on Ms. Miles, Mr. Barnes, and Mr. Pauly.
All right. Lenaria Miles. CR 223839. Ms. Miles is set for pretrial today.
That's correct, Judge. We request that she be set for docket call.
No contested pretrial motions.
No contested at this time.
All right, court will set Ms. Miles for docket call on September 22nd at 9 a.m. Once she gets her notice, she's free to go. Ronald Pauly. CR 2242.
Sorry, Judge. Mr. Pauly has a hearing deficiency.
No problem. All right, Mr. Pauly is set for pretrial.
Yes, Judge. Mr. Pauly apologizes to the court for the confusion on the pretrial reporting. He has been reporting and paying. He just hadn't also been reporting and meeting with Carl. So he has, I believe, been caught up to his pretrial fees, and we're good from what I understand. As I said before, we have reached a resolution in Mr. Pauly's case, and we request that we be set for docket call for our next set.
You have reached an agreement,
Yes, we have, Judge.
so go ahead and set up for plea.
Judge, if we can set for a docket call, I don't think it works.
Okay. All right, court will set Mr. Pauly for docket call on September 22nd at 9 a.m. And the court will note that Mr. Pauly was negative on his urinalysis test. So I appreciate that update from you, Mr. Manning.
About September 22nd at 9. But if you get work before then, you will have to show up.
You're welcome. Brittany Turner, ready, Ms. Turner?
No, Judge, I did not see this turn this time. I'm ready on Mr. Barnes, Jason Barnes.
All right, Mr. Barnes. All right, this is cause number CR 22201, State versus Jason Lee Barnes. Mr. Barnes is set for arraignment today on aggravated robbery. Court has found Mr. Barnes to be indigent and has appointed the Honorable Jonathan Manning. Mr. Manning.
Yes, Judge. I had opportunity to speak to Mr. Barnes earlier and went over the indictment. His name is spelled correctly. He understands the charge against him, the range of punishment. At this time, he entered a plea of not guilty and request to be set on the pretrial docket for September 22nd.
All right, court enters Mr. Barnes' plea of not guilty into the record, finds that he has waived the formal requirements of arraignment and sets pretrial September 22nd at 9 a.m. Mr. Manning, Mr. Barnes will need to sign his conditions of pretrial release after getting his notice.
Yes, Judge.
Anyone further, Mr. Williams, this time?
Judge, I've been in contact with Ms. Pettis this morning. She is unable to get a ride. So she requested, she wanted to appear via Zoom. The option wasn't available to her this time, asked the court on her behalf. I did speak to the court coordinator and found out that Mr. Christopher is no longer in the Coffee County Jail, so I reached out to his family to see if we can locate him. I have not had a chance to reach out to Ms. Gonzalez or to Ms. Turner, but I'm surprised because Ms. Turner has been very diligent. We've gone over discovery. She's been in my office several times. So I'm a bit surprised not to see her at this point.
Okay. All right, I appreciate the update. All right, Mr. White, are you ready with this head?
Yes, sir.
This head. CR 2286, State versus Jamie Lynn Hedden. All right, Ms. Hedden, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you lower your hand. Your name is Jamie Lynn Hedden, is that correct?
Yes.
Ms. Hedden, are you a United States citizen?
Yes,
Do you read, write, and speak English?
I do.
And have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation?
Yes.
Like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
Yes, sir.
Mr. White, do you believe your client to be competent today?
Your Honor, I believe he said he's competent. She understands the proceedings with opinion against her here today. We've also gone over some rights, she's waiving those rights knowingly, intelligently, voluntarily.
All right, I see that Ms. Hedden, you were indicted with a third-degree felony offense of possession of a controlled substance in penalty group 2 between 1 grams to 4 grams. However, it appears that the plea agreement in the case today would be that you would plead guilty to a lesser included offense of possession of drug paraphernalia, a Class C misdemeanor, which carries a range of punishment up to a maximum fine only of $500. Do you understand that full range of punishment?
Yes, sir.
And you understand the plea agreement is that you're going to plead guilty. And in exchange, the state's recommending that the punishment be assessed at the maximum fine of $500 plus restitution for the testing of the substance, in this case of $180 with a $20 reimbursement fee and court cost of $76.
Yes, sir.
All right. So at this time, Ms. Hedden, I'm going to ask you, how do you plead to possession of drug paraphernalia, a Class C misdemeanor?
Guilty.
And Ms. Hedden, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. White, any objection to the state's evidence as offered? No, sir. All right, state's evidence is admitted. The court takes judicial notice of Ms. Hedden's judicial confession. Anything further from the state?
Hey, Your Honor, we rest in peace.
Rest in close.
Should have fixed it. All right, the court's reviewed the evidence. I do find sufficient evidence to convict Ms. Hedden. The court will follow the plea agreement in this case. Court hereby convicts Jamie Lynn Hedden, Class C misdemeanor offense of possession of drug paraphernalia, assesses her punishment at $500. Fine, $180 restitution, $76 court cost, and $20 reimbursement fees. Mr. White, is your client paying anything towards her sentence today?
Yes, sir, she is. I believe she's got to go get the money.
Yes.
Okay, what is she paying today?
I have $65 right now that I have to, and I'll pay some more probably later on this week,
All right, so.
early next week.
So whenever you leave, you need to go down and see the court compliance officer at the end of the hall on the left and set up a payment plan. If you're not gonna be able to pay it all today.
Yes, sir.
And Mr. Woodward, I'll need you to sign these plea papers. All right, Ms. Hedden, you hereby remanded to the custody of the Van Zandt County Sheriff, so we can carry out the terms and conditions of the sentence. I'm gonna have you come forward to look at our fingerprint first. Come forward to get fingerprinted.
That's all I have for this afternoon.
Yes, sir. See you in a second. Andrea Young. Ms. Young, Mr. Steele is appearing via Zoom today. So we're gonna give him just a moment. He should log in. All right, good morning, Mr. Steele. Can you see and hear me okay?
Yes, Judge. Good morning.
All right, I have your client here in the courtroom, Andrea Young, CR 22-121, and she is set for pretrial.
Yes, sir.
Any announcements, any contested pretrial motions?
I don't have any yet. When I was looking, I got the discovery between last court date and today. And then I was looking through the discovery and there was a video, and I informed Tyler that there was a video, and he did get the video to me the next day. He got it to me as quickly as he could. That was July 28th or 29th. And I have not had a chance to get down there to pick up that video, but I do know it's out there waiting. I asked if my client could pick it up, and they said that my client can't pick it up for me. So I will pick up the video no later than Friday or Monday, but I haven't had a chance to watch the video.
Okay. All right, so you're asking for an additional pretrial setting?
Yes, Judge.
All right, any opposition from the state? All right, court will reset Ms. Young. Mr. Steele, are you available on September 22nd?
Yes, sir.
All right, court will reset Ms. Young for September 22nd for pretrial. That will be at 9 a.m. Ms. Young, if you'll sign that notice there, we'll give you a copy and you'll be free to go. And that's all you have on today's docket with me. Is that correct, Mr. Steele?
Yes, Judge. Thank you.
All right, we'll be adjourned.
All right. Thank you. Have a good day. Have a good day.
You too.
Thanks. Bye.
That is.
Is Mr. Jeff Watt still working on plea papers with Miss Chitty? Do we know? In the silent treatment. I'm good. I'm good at receiving silent treatment. Okay. All right, this is cause numbers CR 2291, CR 2292. State of Texas versus Carmelita Maria Chitty. Ms. Chitty, if you'll raise your right hand, I'll place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Ms. Chitty, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? And in this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about these sets of paperwork that you've read and signed that you do not understand? Mr. White, do you believe your client to be competent today?
She's competent to make the decision she says she's made today.
And you've explained to her legal rights in these cases?
I have, Your Honor.
You believe that she understands
She does
those
understand.
rights and the waivers that she's making?
She does understand.
All right, Ms. Chitty, I see that you were originally indicted with a state jail felony, 2 counts of state jail felony in each cause of abandoning or endangering a child with criminal negligence. However, I see that the plea agreement today is that you would plead guilty to a Class C misdemeanor offense of crimes against person leaving child in vehicle with a range of punishment up to a maximum fine of $500. And I see the plea agreement in this case is that you would plead guilty to that crime. And the state's recommendation for punishment is that the court assess a $500 fine. In addition, you would be responsible for court costs and reimbursement fees. Is that your understanding of the plea agreement? And that's what you're asking the court to approve?
Sir.
All right, Ms. Chitty, to the offense of leaving child in vehicle, a Class C misdemeanor in cause number CR 2292 and CR 2291. How do you plead to each one of those crimes?
Guilty.
Are you pleading guilty to each of those crimes because you are guilty of committing each of those crimes? All right, court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objections to the case, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we have some.
from the defense?
Nothing, Your Honor.
Mr. Woodwine, I'm looking at the state's evidence. I'm not seeing an indictment in CR 2291. Appears to have the same indictment and stipulation of evidence, which is only CR 2292.
So you can see our make it one judge.
Yes. Right, any objection to the indictment in CR 2291 being added to State's Exhibit 1?
No objection.
All right, court will amend State's Exhibit to include the indictment in CR 22. All right, court has reviewed the evidence in each case. The court finds that there is sufficient evidence to convict Ms. Chitty of these offenses. Court will follow the plea agreement as recommended by the state. Court hereby convicts Carmelita Maria Chitty of leaving child in vehicle in cause number CR 2291 and 92. Court convicting Ms. Chitty of the Class C misdemeanor offense assesses punishment at $500 fine. Orders her to pay fine in addition to court costs of $76, reimbursement fees of $20. That sentence is respective in each case. Mr. White, is Ms. Chitty paying her fines in fees today?
She will be needing to set up a pay. I will show her where she needs to go.
All right, Ms. Chitty. What do you think about all of this? You've had time to reflect on it. What do you think about it?
I made a very bad decision.
Yeah, I would say so. It's one thing to do drugs and make that decision for yourself. It's one thing to be intoxicated and make poor decisions. But I'm assuming that you were sober when you left the kids in the car to go into the bar to drink. Is that right? So you intentionally did it. And you were in your right state of mind. You weren't intoxicated. Do you ever watch the news?
Not really. Yes, I do.
Really?
I do watch the news. No.
Do you know how many kids are abducted every day? Every day from Walmart. Kids being left in cars, not to mention all the kids that die being left in cars. Little kids, these are your nieces, niece and nephew, right? You're there with your sister, younger sister, right? So you're the big sister. It's pretty stupid. It's very stupid. You're very fortunate to get the plea agreement that you got. I think I know what a jury would do if you went to trial on a case like this. And they would leave you somewhere. I think they would leave you locked up. So you better be thankful. And I hope every time you look at Emery and Eli, you're thankful for the fact that they're not dead, kidnapped, sexually assaulted, killed, dumped in a ditch somewhere. Because I see that. That happens all over our country. These little kids only have those adults that are around them to protect them. And that includes you. Well, they're not your kids. You're responsible for that. So hope you think about that. Hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with the deputy. Then I want you to go make whatever payment you can make today to the clerk and then go to the other end of the hall and meet with the compliance officer.
Thank you.
Come on forward. You may. All right, this is cause number CR 2261, the state of Texas versus Shane David Baronet. Mr. Baronet, if you'll raise your right hand, sir, place your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Yes. All right, lower your hand. Mr. Baronet, are you a United States citizen? Yes. Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? Minor depression. Are you currently undergoing treatment or on medication for that? Yes. Do you feel like you have a rational understanding of what's going on here in court today? Yes. Mr. Mims, do you believe Mr. Baronet to be competent today?
He's competent, Your Honor.
And are you aware if he has any other mental health issues other than what he stated?
I'm aware that he was, had some time at Terrell State on some other issues, none related to this.
And Mr. Mims, you've explained to Mr. Baronet his legal rights as they pertain to this case.
I have, Your Honor.
You believe that he understands those and the consequences of his plea today?
I believe he does.
Mr. Baronet, you have been charged by indictment with the second-degree felony offense of aggravated assault with a deadly weapon. That does carry a range of punishment if convicted and sentenced to a minimum 2 years in prison to a maximum 10 years. I'm sorry, to a maximum 20 years in prison and a fine not to exceed $10,000. Do you understand that full range of punishment, minimum 2, maximum 20? Yes. All right. And Mr. Baronet, you understand that the plea agreement, as I see it, is that you would plead guilty to that charge today. The state would be recommending to the court that the court convict you of that offense and that the court sentence you to 10 years confinement in prison with a $2,500 fine plus court costs and reimbursement fees, and you would receive 130 days credit towards that sentence for time that you have spent in jail on this cause. Is that your understanding? Yes. That's what you're asking the court to approve? Yes. All right, Mr. Baronet, how do you plead to aggravated assault with a deadly weapon? Guilty. Are you pleading guilty to that crime because you are guilty of committing that crime? Yes. Court accepts the defendant's plea of guilt. Mr. Mims, any objection to the state's evidence?
Sorry.
Any objection to the state's
No,
evidence?
Your Honor.
State's evidence is admitted. And the stipulation of evidence, the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
This, Your Honor, there is a big impact as well as prosecution. With that stipulation.
Anything further from the defense, Mr. Mims?
No objection.
And does the defendant wish to be heard on any other issue regarding this plea? No. All right. Court is going to review the evidence. All right, the court has reviewed the evidence. The court does find sufficient evidence to convict Mr. Baronet. Court hereby follows the plea agreement in this case, convicts Shane David Baronet of aggravated assault with a deadly weapon, second-degree felony. Court finds that a deadly weapon was used in this offense, more specifically described as a firearm. Court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. Court orders him to pay a $2,500 fine, $290 court cost, and $40 reimbursement fees. Court awards Mr. Baronet 130 days credit towards his sentence for the time that he has spent in jail on this cause. All right, Mr. Baronet, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. at which time you'll be taken into custody. After being taken into custody, then the court will allow the victim allocution, which the court will direct there not to be a record. So you can go to that table right there. Take that over there, Brian. And Mr. Mims, there's a bill of costs that was in the plea agreement that needs to remain with Mr. Baronet. This is his copy.
Approach.
Yes, please. Yes, this will remain with him.
It's given one, his wife has it.
It's a copy.
He's already got
He's already got one. Give it to us, Mr. Baronet. Yes, and Mr. Baronet, if you'll just have a seat in the council chair right over here next to Mr. Mims. Mr. Woodwise, the court will recognize the victim of this case and the request for allocution. And that allocution can be held here at the witness stand or at any other place in the courtroom that the victim feels comfortable.
Unfortunately, you ain't tissues. So I'm sure I'm
Yes,
tearing
I
up.
do.
Thank you. My name's Brad Bell. That gentleman right there, November 29th, Shane, showed up on my property, unannounced, uninspected. For whatever reason, had no reason whatsoever. I've lived on that property for over 7 years. Raised my kids. Had my wife. Had no problems whatsoever until that day. That man came over there. After talking in the shop, went out to his truck, opened his door up. I was within 20 feet from him. Pulled his rifle out. Asked me a question as far as if I was lying to him. There's nothing I was lying to you about. Then, now, forever. You then put the rifle down, called your dog. Dog got in the truck. You got in the truck. Then you pulled the rifle back up and you said, I'll just shoot you. As soon as you finished that sentence, you pulled that trigger. Now I'm running up. I fall. You pull a trigger again. Now, angels, God, heaven above, made me fall when you pull the trigger a second time. Went and warned my wife. Told her to call 911. Therefore, I was laying down on my back porch on my side, internally bleeding because the bullet did not leave my body. It is still in my spine today. And it will be in my spine for the rest of my life. So there I'm internally bleeding. I remember everything. All we get into the ambulance. I remember who was there that day after that had happened. prior to going in the ambulance. Your wife running up there saying what she was saying. But now I died. Like they got me to the hospital. I flatlined, died 6 times when they stopped counting. They had my wife, my parents, my kids say their goodbyes to me over something you did. But you know what? I fought. I took 60 units of blood that night. 6 surgeries during that week. They cut both of my legs from my knees to my ankles on both sides because you destroyed the return blood vessel line. You destroyed my intestines. I was in a coma for a week, medical induced coma, because apparently I was in so much pain. Waking up, realizing what all they did to me. They're going to cut my legs off because they could not stop the blood from bleeding, the internal bleeding. But to God, I'm here. That Bible ain't going to help you because of what you did, decisions you made that day. But I have to live the rest of my life knowing what you did to me. PTSD, getting shot, wearing compression stockings for the rest of my life, taking blood thinner for the rest of my life, and got your bullet in my back. I had to move after you got bonded out. Place where I was going to retire at, raise my kids up, have grandkids and what have you, because I felt unsafe because you was within 500 feet from my property, living your life when you got out of jail, going back working on cars and everything else. I have not worked since November 29th, buddy. I have not brought in any income, period, since then. I still have one more surgery to go through over this crap. Sorry, sir, over this. Because of the actions you make. And all you're getting is 10 years. I get the rest of my life to live, but I get the rest of my life with damages that you have done to me, mentally, physically, emotionally, and financially. And all you do is hope you rot in the 10 years. It should be more. It should be a lot more. And if you ever do get a chance of parole or where, I'll be there. Every chance I get, I'll be there. Because you're dangerous to society, buddy. Period. You're a danger to your family. You're a danger to me. You're dangerous to your neighbors. You're a danger, period. People like you, there's no excuse. When y'all make the decisions that y'all make, it's wrong. You knew it was wrong when you pulled the trigger the first time. You knew it was wrong when you pulled the trigger the second time. But unfortunately, I remember it all. And so will you every night. And I hope every night is a month for you for the 10 years. So unfortunately, I can't say anything else. But apparently, it's all I can say right now. But people like that, like I said, I have 3 kids, a wife. And over decisions you was about to make. And unfortunately, they weren't down in my shop that day. Thank goodness. Thank God. But I am a fighter and I am stronger than you. But as human beings, we live to make the decisions that we make in life. Right, wrong, or indifferent. You knew that growing up as a kid. I knew that as growing up as a kid. But luckily, I'm here walking on my 2 legs. They're not cut off. Luckily, I'm here alive, not 6 foot in the ground. but God will do what he needs to do. That's all I got to say.
Understood. Would like, all right, we'll be adjourned in this case. Yes, we're adjourned in this case. Yes, thank you, Mr. Mims. Mr. Manning. You can come this way too, Mr. Manning. You come up to them. You can move that so she can walk through. Is that your client? Is that Ms. Turner? Ms. Turner, come on up. All right, this is cause number CR 21400, State versus Brittany Turner, receptive pretrial, Mr. Manning.
Yes, Judge. If you remember last time, we made an announcement. Ms. Heisel was seeking CPS records. As of last week, when I spoke to her before going to conference, she had not received those records, or had opportunity to review any records that she had received. And so she agreed to additional pretrial sitting on Ms. Turner's case. We'd ask that be set out for the September 22nd docket.
All right, court will set Ms. Turner for additional pretrial on September 22nd. That will be at 9 a.m. Turner, remind me again why you were late today.
High car issues.
Corrections.
I was older and I was here yesterday. Well, not here, but I've been driving back and forth Dallas to Tyler and Dallas to Canton. Or my children, so.
All right, once you sign and get the yellow copy, free to go. All right, so Mr. Zappa is here. Is his client here, Megan Tyler? Ms. Tyler, you'll come on up. Good morning, Mr. Zappa.
Morning, Judge.
All right, this is cause number CR 2318, State versus Megan Devine Tyler, set for pretrial. Mr. Zappa, any contested pretrial motions that the court needs to set hearings?
No, Judge.
All right, so what I'll do, Mr. Zappa, is I'll just set a docket call, and that'll give you and the state time to complete any negotiations that may be going on in this case. Once docket call gets here, then I just want to hear an announcement from the defendant on whether there's going to be a plea agreement or a request for a bench trial or a jury trial. Court will set Ms. Tyler then for docket call. If you have your calendar, Mr. Zappa, the dates I'm looking to set are either September 20th, 22nd, or possibly the 27th.
Let me look, Judge.
Yes, sir. Will you get, I'll call him just a second. You have a date, you have a date issue?
I just wanted to be able to check my work calendar as well, if that's okay.
Do you have that with you?
I have it on my phone.
Yeah, go ahead, check it.
You said the 20th, 22nd, and 27th of September.
Yes, sir.
The 22nd and 27th look, well, hold on. The 22nd or the 27th look good for me.
Miss Tyler's checking her work schedule.
It would have to be the 22nd for me.
Okay, well, we'll do that. All right, the court will set Miss Tyler then for docket call on September 22nd. That'll be at 9 a.m. And Miss Tyler, you were arrested on this case outside of Van Zandt County, is that correct? Were you-
Yes, sir.
Okay, so Van Zandt County needs to get a copy of your fingerprints. And the way that we're gonna do that is Ms. Tabraham's gonna provide you with a copy of an order. It's a fingerprint processing order. I need you to take that after court today and go out to the Van Zandt County Justice Center, the jail out on 64 going west. Just go in there and tell them you need to give your fingerprints, show them that order. They're just gonna take you back. They're gonna take your digital fingerprints and then you'll be free to go. Okay?
Is there a way I could just get that sent from Collin County or not?
No.
Okay.
Yeah, it's easier for us just to do it that way. Years ago, that was the way you did that, but for whatever reason, there's a breakdown in that. But if you'll just go in, they'll process you quickly, efficiently. They're just gonna take your digital fingerprints on glass and then they're not gonna change you out or anything like that. But you may have to be patient as they get a staff member to handle that, okay?
Okay.
All right, so I want you to go right after court and get that done. All right, so is there a notice of setting, Ms. Abraham? All right, so Ms. Tyler, if you'll sign that notice of setting saying you'll be back on 9/22. We're gonna give you a yellow copy here for your
But
records.
ask to have a copy.
You're gonna get a copy. And then Ms. Abraham, if you'll take her and give her a copy. And so you can go, Ms. Abraham, she's gonna give you a copy of that fingerprint order and then you're free to go.
Okay.
Okay.
All right. Thank you.
You're welcome. Thank you, Mr. Zappa.
Judge, unless I'm notified otherwise, clients in person and I'm on Zoom.
No, both in Zoom, both on Zoom.
Oh,
I'm
both
sorry,
are Zoom.
I'm sorry, excuse me. Both in person, both in
Oh,
person.
okay, gotcha.
Yeah, docket call is kind of the end of the case. I'm looking for, there's an opportunity for everyone to get together and make the
Right.
decision. Because my policy is once we get past docket call, if an offer is made and it's rejected, then I'm just gonna set it for jury trial, jury selection, unless there's a bench trial requested, and then I don't accept plea agreements after that day. So I want everyone to kind of get into the room together to see if we can't get it finalized.
Got it, Judge. Thank you.
Thank you, Mr. Apple. Mr. Manning, do you have anyone else? I don't see your client on Zoom.
I've been, as she was attempting to download the medical documentation to provide the court. I told her the court thing this time to get her on Zoom so we can reset her. I got her back, that was about 20 minutes ago. I provided her the court's Zoom ID as well as the condition, her information of the conditions. Upon reset, like I said, I don't turn the phone.
Okay.
Ms. Turner.
We're waiting. Everyone else will be nice eyes.
Are we gonna wait on?
No, Miss Turner appeared. That was Miss Pettis. Says he's talking.
Oh, Miss Turner did appear.
Yeah, Miss Turner was here. We just get to the days. And we reset her to 9:22. All right, Mr. Manning, I don't want to hold you over, so you're free to go. If Ms. Pettis logs in, I'm going to tell her to log back in at 1:30. And we'll deal with her on Zoom at the, you'll be at the jail this afternoon, correct?
That's correct.
All right, I don't want to hold you over. You're free to go, sir.
Thank you.
Judge, I know I've been losing my mind lately with the lady up there. Is that who you think that was Miss Turner?
Ms. Turner was
Before that, okay.
She was taller. but-
During the,
Yes.
okay.
Yeah, she came in fall,
Yes.
These are the names that I would like to have called.
Yes, sir.
Randy Dobbins.
Yes, sir.
Randy Lee Dobbins. Martise Heath.
Yes, sir.
Jennifer Wall.
Yes, sir.
Carlos Gap. You may.
Note for the docket, did we call Mr. Bird's case this morning? He's the one that's in Rockwall County.
Mr. Who?
Zachary Bird. That's good. Do we have? Carlos. And we have confirmation, he's still in Rockwall.
Carlos Gatlin, yes, sir.
Mr. Manning, we do need to talk about Bobby Brand. I'm gonna reset that for arraignment 9:22. And then I'm gonna NISide the vendor advisement. I'll give, let's give it to the end of Monday. Do end of Monday to get hospitalization records.
He was previously in a mental hospital in Cedar Creek area, Housing area. So I'll try to get the updated record.
Yeah, we can just, yeah, I'll take I'll take it under advisement until Monday at 5.
It's just, thank you.
All right, I'd like to name Bobby Brand. Polls.
Yes, sir.
Glenn Christopher.
Yes, sir.
Jennifer Gonzalez.
Yes, sir.
Haley Pettis.
Yes, sir.
Probably that's. Who?
Randy Dobbins.
Randy Dobbins.
That
Oh, sanctions. All right, so don't need to call them. Don't need to call Randy Dobbins. Amendment. Think of my thoughts back there.
Yeah, second on top of it.
Yeah, we can move them. All right, board that's called. Court has had their name called loudly distinctly 3 times in the courthouse with no response. The court will issue judgment nisi and alias capias. However, the court will be taking under advisement the nisi and alias capias for Jennifer Rollins until Monday, 5 p.m. For documentation to be provided by Mr. Clay Nicholas with Roy Brockway bail bonds. Court will be taking the nisi and alias capias under advisement for Carlos Gatlin until Monday, 5 p.m. for Mr. Adams to get the verification from Mr. Gatlin regarding his presence in the ER on this date. Court will be taking under advisement the nisi and alias capias for Bobby Brand until 8:15 Monday, close of business at 5 p.m. For Mr. Manning to provide documentation regarding Mr. Brand's hospitalization in the Millwood Hospital in Arlington. Court will take Kaylee Pettis's nisi under advisement until 1:30 today, which the court has ordered her to appear via Zoom for the working audio and video connection. That will conclude this morning's criminal docket. The court will stand in recess until 1 p.m.